do beg leave to withdraw my amendment, and obviously I'm doing so on the basis of the government having given a commitment to carry out the terms of my amendment in full, and I am happy to participate with the further discussions which the noble lady, the Minister, said she would wish to have with me. So I beg leave to withdraw my amendment.
Is it your Lordship's pleasure that motion A1 be withdrawn? Motion by leave withdrawn. Motion B, Baroness Williams of Trafford.
Lady Carter. The question is that motion A be agreed to.
I'm sorry, should I have said something else? I'm so sorry. The question is that motion A, this isn't as easy as it looks, you know. The question is that motion A be agreed to. As many as are of that opinion will say content. To the contrary, not content. The contents have it. Thank you. I now call motion B, Baroness Williams of Trafford.
My Lords, I'm glad I'm not the only one. I beg to move that this House do not insist on its Amendment 2 as set out in motion to which the Commons have disagreed for their reason 2A. My Lords, Amendment 2 was also disagreed with in its previous form by the other place. It seeks to continue certain family reunion arrangements provided by EU law, the so-called Surinder Singh route. Amendment 2B, tabled in lieu by the noble Baroness Lady Hamwee, would require the government to provide rights for British citizens resident in the EEA or Switzerland by the end of the transition period to return to the UK accompanied or joined by their non-British close family members on current EU free movement law terms until the 31st of December 2040, that is for a period of 20 years from the end of the transition period. They would retain preferential family reunion rights for that period. For the next 20 years, family members of British citizens living in the EEA or Switzerland would continue not to be subject to the same immigration rules as family members of other British citizens. This perpetuates a lack of parity which the government can't accept. Family members of British citizens resident in the EEA or Switzerland at the end of the transition period are not protected by the withdrawal agreements in terms of returning to the UK, but we have made reasonable transitional arrangements for them. British citizens living in the EA or Switzerland will have until the 29th of March 2022 to bring their existing close family members, a spouse, civil partner, unmarried partner in a long-term relationship, child or dependent parent to the UK on EU law terms. The family relationship must have existed before the UK left the EU on the 31st of January 2020 unless the child was born or adopted after this date, and must continue to exist when the family member seeks to come to the UK. Those family members will also then be eligible to apply to remain in the UK under the EU settlement scheme. Family members will be able to come to the UK after the 29th of March 2022, but will then need to meet the requirements of the family immigration rules. Those rules apply to the family members of other British citizens, irrespective of where they come from, and reflect the public interest in preventing burdens on the taxpayer and promoting integration. This is a fair and balanced policy. It was announced on the 4th of April 2019, so those affected will have had almost 3 years to decide whether they wish to return to the UK by the 29th of March 2022 on current EU law terms, and if they don't, to make plans to do so. The government's approach strikes the right balance between providing sufficient time for British citizens and their family members living in the EEA or Switzerland to make decisions and plans for returning to the UK, and ensuring equal treatment of the family members of British citizens under the immigration rules as soon as reasonably possible once free movement has ended. We must be fair to other British citizens, whether they are living overseas or in the UK. The same rules should apply to all, not continue for the next 20 years, to give preferential treatment to those relying on past free movement rights, which will have been abolished. That is what a fair global immigration system means. And I hope that noble lords will not insist on Amendment 2 or to agree to Amendment 2B in lieu. I beg to move.
The question is that motion B, that this House do not insist on its Amendment 2, to which the Commons have disagreed for their reason 2A, be agreed to. Baroness Hamwee.
My Lords, I wish to move Amendment B1. I am moving an amendment similar to that which was moved at previous stages, but with a change to meet one of the points made against it. It came as a shock to me to learn that there will be restrictions on and conditions applying to a UK citizen wishing to return to the UK with a non-British family. At the committee stage, I asked what the Minister would advise a couple with elderly parents in both countries, for both of whom they wanted to care, which rather follows on from the previous amendment. Following that, I received many emails describing many varied families affected. They all explained the anxiety they felt. The minimum income requirement will apply, as the Noble Baroness has said, after March 2022, as it applies now to a UK citizen wishing to bring a non-UK, currently non-EEA family to this country. I've always felt that the MIR is very harsh. It presents real difficulties, including as regards the spouse's contribution to the household income. And in the 21st century, most households are necessarily two-income households. And in response to the point that these families should be treated the same as families who include non-EEA citizens, I'd say it shouldn't apply to them either, but that would not be within the scope of this bill. I would have liked to have taken that opportunity. And those families will, in very, very many cases, have been aware of the situation when the family unit was created. I understand the government's concern that EEA citizens should be treated the same as the rest of the world after the end of free movement, but the situations are not exactly the same. When marriages were made, families created, after we had acquired rights of free movement, who would have given a thought to what might happen if they ended, or indeed given thought to whether rights might end? And who in the British military, who met their spouses when they were serving abroad, would have contemplated this situation? I do hope that the Secretary of State has read their letters. The provision may not be retrospective in a technical sense, but in an everyday sense, it is. This is not something that is widely understood, even now. The government's original proposal in June 2017 did not deal with the issue. The public announcement of the 2022 date, as the Noble Lady has said, came out in a paper in April 2019. It's been presented as a concession. That paper said that the government recognised UK nationals needed certainty. This was after we were supposed to have left the EU. I wondered whether I'd missed something here, so I checked on what had been done and when to make people aware of the position. Had the Foreign and Commonwealth Office attempted to draw this to people's attention? Had our embassies raised it in local town hall meetings abroad? One rather dry comment made to me was that if these citizens had voting rights, the embassies would have been able to make direct contact with them. I understood that the targeted FCO campaigns have largely been focused on rights in the host country, advising people to register and to change their driving licenses, for instance. On the living in France, living in Italy, and so on pages on gov.uk, I clicked through ending your time living abroad. And after a couple more clicks found, because I was looking for it, bringing your family, which told me a visa would be needed for them. One might easily stop there. Immigration rules required further clicks, and so on. I understand that all this is still coming as a surprise and, of course, a shock to those who happen to trip over it. An EU citizen here now, or by the end of this year, can bring in family members, and quite right too, but not right for our own compatriots. This is discrimination against UK citizens. And it's not as if what we are proposing would open any sort of floodgates. It's self-limiting. No one would qualify after free movement has ended. It's not a perpetual or a forever right, as has been badged. Criticism was made at the report stage that there was no cut-off date by which an UK national must return to the UK, and ministers say that the 3 years gives a reasonable period to plan. So this version includes a cut-off date, deliberately long, 20 years after the end of the transition period, because by then, most of those affected who formed settled relationships and families are likely to be over 50 with parents of 70 or 80, so their families would be in a better position to know whether returning to the UK is likely to be necessary. The Minister in the Commons presented the 2022 date as needing, I quote, to be fair to other UK citizens, as if there is something other about UK people who have married people from the EA. He also said the government would keep the policy under review. So I'd be grateful if the Minister today could expand on that. When, how, with whom? The Minister has described the government policy as simple fairness. We disagree. What we are proposing is what I'd describe as fair, and I will wish to test the opinion of the House. Thank you.
The question is that motion B1 as an amendment to motion may be agreed to, and the following members in the chamber have indicated they wish to speak: Baroness Ludford and Lord Oates. So I now call Baroness Ludford.
Thank you, Madam Deputy Speaker. My Lords, I agree with everything that my noble friend Baroness Hamwee has said. The noble lady, the Minister, said that the arrangements the government have made are reasonable. But I think one also has to think of the reasonable expectation of British citizens who moved abroad and married, set up partnerships, had families with citizens from elsewhere in the EEA. They had no reason to suppose that the conditions and rules under which they did that would change. After all, the promise of a referendum in 2015 came somewhat out of the blue. It really wasn't well expected. So I think what my noble friend's amendment does is to accommodate those reasonable expectations in a fair way without, while on the other hand meeting the government's apparent objection that they don't want a period of time which is unlimited. Now, in 2017, the Conservative manifesto for the general election promised to legislate for votes for life for Britons living abroad. That has not happened, but at the time, the Conservatives rejoiced at scrapping what they called the Labour government's arbitrary 15-year rule. I think one could also describe the government's rule in this scenario for UK citizens living in the EU of 3 years as arbitrary. Mr. Chris Skidmore, who at the time was Minister for the Constitution, said, "British citizens who move abroad remain an important part of our democracy, and it is important they have the ability to participate. Our expatriate community has an important role to play." And I think one can deploy that in this context. These were valuable sentiments about Britons living abroad, and I would transfer them to say that British citizens residing elsewhere in the EEA should have the right to participate not only politically but economically and socially in this country. And to put them now in the quandary of having to decide by March 2022 what their family circumstances with parents and children could be in the decades ahead is an unnecessary and arbitrary and unreasonable imposition. So I think 20 years is a highly reasonable proposition. The Conservative Party has long claimed to be the party of the family. please can it demonstrate that it is the party of families of UK citizens who took advantage, in reasonable expectation of free movement rights continuing, to live and set up home and set up families with citizens from the rest of the EEA, and now are placed in extremely difficult and worrying and anxiety-producing circumstances. It is not fair play to them to do that. And I think that my noble friend has given the government an opportunity to find a way through this which preserves honour and fairness all round.
My Lords, I will only speak briefly because my noble friends Lady Hamway and Lady Ludford have comprehensively set out the injustices that will be visited on thousands of British citizens and their families if the government's policy stands. I'll just make 2 points. Firstly, the argument that making the existing right of retaining the existing rights of UK citizens with EEA spouses or families somehow is discrimination or unfair against UK citizens with non-EEA spouses has no merit to it. And I speak as a UK citizen with a non-EEA spouse. When we made decisions about our lives, we did so in the knowledge and understanding of the rules at the time, just as UK citizens with EEA spouses made decisions about their lives on the basis of the rules at the time which they could have had no reasonable expectation would change. The only way one could say that discrimination would occur would be if this amendment suggested that if UK citizens who formed relationships with EEA citizens going forward were afforded different rights. But that is not what it says. My second point is this. Yesterday, your Lordship's House passed 2 amendments in lieu on the subject of agri-food standards. They were important amendments, and I was pleased to support them. But this amendment, I would venture, is much, much more important because it is about people's lives. And if it is not passed, a huge amount of misery will be inflicted on a large number of people's lives. And my Lords, I don't think we have really understood the level of suffering that will be inflicted. And frankly, it's wrong, and it is heartless, and we should not allow it to stand.
Does anyone else in the chamber wish to speak? I haven't received any notification, no. In which case, Lord Rosser.
Yes, we do not minimise the importance of this issue any more than we minimise the importance of any of the amendments and the issues they covered, which this House sent to the Commons and which the Commons rejected. British citizens who move to other EU countries, as has been said, will lose the right they had to return to this country of birth with a non-British partner or child, perhaps to look after an ageing parent, unless they can meet financial conditions that will be beyond the reach of many. And whilst British citizens who've moved to the EU or EEA before the end of 2020 will face these new restrictions, EU citizens who've moved to the UK before the end of 2020 will not. However, whilst this issue of the right for UK citizens to return with their family was referred to by some speakers during the course of the Commons proceedings on Monday, it was not, I believe, taken to a division, which does rather indicate that we've now taken this particular matter as far as we can at the present time, having sent it to the Commons once. For that reason, we will abstain if Amendment B1 in lieu is taken to a vote. In the Commons on Monday, the government said they would continue to keep this area under review. And we call on the government to continue to look further at this issue, in which I declare a personal family interest, outside of the bill and well before the deadline date for bringing existing close family members to the UK on current EU law terms of the 29th of March 2022.
Minister.
Could I start by thanking all noble lords who have spoken to this particular amendment, and just start with the noble lord, Lord Rosser, who rightly points out that the Commons didn't actually divide on this matter on Monday, and just remind ourselves that actually the British people voted to leave the EU in 2016. We are now 4 years on from that point. And of course, to answer Noble Lady Hamway, of course we keep all legislation under review and policy, and of course we are assisted by the MAC in that endeavour. And we do recognise that UK nationals who move to the EU expecting free movement rights to continue, and that is why we have provided for these transitional arrangements. But we do have to be fair to other UK nationals, whether they're living overseas, beyond the EU, or indeed in the UK. And the UK family immigration rules reflect the public interest in preventing burdens on the taxpayer and promoting integration. UK nationals, of course, protected by the withdrawal agreement because they are living in the EEA before the end of the transition period, do of course have lifetime rights to be joined by in their host state by existing close family members, and this mirrors the rights of EEA citizens living in the UK by then. And the noble Lady Ludford challenges me on the date of the 29th of March 2022 as an arbitrary one. That date represents 3 years after the date that the UK was originally supposed to leave the EU. And for me, it strikes the right balance between providing sufficient time for UK nationals and their family members living in the EEA or Switzerland to make decisions and plans for returning to the UK, and ensuring equal treatment of family members of UK nationals under the immigration rules as soon as reasonably possible once free movement to the UK has ended.
Baroness Hamway.
Thank you. I'm, of course, grateful to my noble friends who've supported this amendment. I do hope that my noble friend Baroness Ludford I never give her cause to look up what I've said in the past. And I'm grateful particularly to my noble friend Lord Oates, who, if you will, embodies the point that I have been making about the different positions between those who are married to married EU citizens not knowing what was coming down the road, and those in his position. I'm disappointed in Labour's response to this, because this is a legislative opportunity quickly to get this sorted. Both Lord Rosser and I asked about keeping the policy under review, but it sounds from the Minister as if this is no more than the normal keeping of policy under review. No detail, no particular plan, no timetable. It's not what the noble lady has said is not a reason not to pursue this amendment. And as my noble friend says, this is not fair. I beg to test the opinion of the House.
Is that motion be one